Good morning, all. I'm Bree Joyner, Senior Director, MSRB's Market Regulation Department. I'm also the MC for today's event. We are delighted to have so many of you joining us in person and also virtually. Before we get started with our programming, just a few housekeeping notes. With respect to questions, to submit questions, please use the QR code that appears on the conference slides. Each panel will attempt to get to as many questions as possible, but we do have a chock-full agenda today. Your questions, of course, will be submitted using your personal devices. Also, if you've submitted questions in advance, we really appreciate those that took that time. Moderators have reviewed those questions and have selected those that are relevant to their panel topic in order to weave those questions throughout the discussion. Lunch, the thing that everyone's going to be interested in a little later. As a reminder, lunch is going to be on your own. So for those in person, please take a look at your confirmation email. It has a list of restaurants that are in walking distance to this location. Please also allow yourself enough time to get back from lunch to go through security again so that we can start our program on time. Now, Jason Bird, Director of the SEC's Denver Regional Office, will come up with opening remarks. After opening remarks, we will turn to panel 1 on MA disclosure obligations. This panel will touch on anti-fraud provisions and fulfilling contractual obligations. Thank you. Jason?
Well, thanks for the introduction and welcome. My name is Jason Bird. I'm the Director of the Denver Regional Office, and I have been for the past few years. Before I begin, I just want to give the official disclaimer, and I'm going to try to make this a blanket disclaimer for everybody at the SEC, but I'm sure you'll hear it again throughout the presentation. So my and the other SEC officials' comments today are provided in our official capacities as SEC employees, but they do not necessarily reflect the views of the Commission, the commissioners, or other members of the staff. So with that out of the way, again, welcome to Denver. For those of you who are locals, obviously you know what Denver offers. For those of you who are not, I hope you get to enjoy some of the spoils that it does have to offer. And I appreciate everybody making your way here. Special thanks to the co-hosts of the event, the Municipal Securities Rulemaking Board, and the Financial Industry Regulatory Authority. We're excited to bring everybody together here, and I understand this is the first in-person event since maybe 2019 when it was in San Francisco. I have no idea how present-day Denver is going to compare to pre-pandemic San Francisco, but I hope it's favorable. So my exposure to the muni markets dates back to when I first started at the SEC. I was an examiner back in, I think, 2006 or 7, that time frame. And during that time frame, my first exams were related to corporate and municipal bond markups. And I look back to that time where I was doing those examinations as just a little bit of insight into the municipal securities markets generally, and how things work. And what struck me, apart from the fact that there were so many daisy chains in between retail customers and other dealers, and the fact that contemporaneous cost is always going to be ingrained in my head, was that I remember focusing on the muni bonds as opposed to the corporate bonds. And for those of you in the room who have been in this area for a while, you understand why. There was less liquidity in the market. There were higher markups, more inter-dealer interactions that caused retail customers to be getting, I think, less than favorable pricing. And again, it's obvious to everybody in the room, but that was driven by a lack, or at least less, sophistication in the muni world than what appeared in the corporate world. The muni markets have been subject to less supervision over the years, and market participants generally have less information than they do in other securities market areas. And that's why I think it's paramount for municipal advisors and dealers to pay particular close attention to disclosing conflicts and in making sure that they adhere to their fiduciary duties to their clients. So to take a step back from the actual muni world, just to highlight things that I think are always important in these types of events. They're always meaningful to me because we see everybody as a partner, not only as a partner, but a lot of you as gatekeepers. And your efforts are in line with the SEC's efforts, where we are trying our best to make sure that investors have the information they need to make informed decisions. And there's always opportunity for a back and forth during these events to have discussions between regulators and industry participants that I think are invaluable and go a long way in making it so that we're not ships passing in the night. So people understand what the SEC is expecting, what the priorities are, and then can tailor their businesses to accommodate or at least make sure they're complying with the areas of focus that the SEC has. So the program today and tomorrow, I think is going to be great, and I feel like a little late night talk show host as I say that out loud. It's going to include discussions about various substantive areas that I think all of you are interested in: disclosure obligations, fiduciary duties, and importantly, we're going to have panels with regulators, both on the exam side of the house and enforcement side, to give you some insight into what the priorities of the SEC will be. We have outstanding speakers who are going to be here, and I want to just acknowledge the fact that we have such great speakers who will be here from the MSRB, FINRA, the SEC, and the industry. And having sat on a call earlier this week, I haven't seen her today, but with Rebecca Olson from the SEC, I assure you, you're in very good hands. There she is. You're in very good hands, and will be filled with knowledge, as I am every time that we speak. So again, just a couple housekeeping things before I pass the baton to the first panel, and they were said out loud a second ago, but just to reiterate, if you have a Q&A, that's conducted through the app, and the QR code is on everybody's, or should be on everybody's desk here. There will be an opportunity for participants to meet with the regulators. There is a breakout room, I think across the hall from this conference room, where those types of discussions can happen. And then there are lunch recommendations. I know there are many panelists who are from out of town. I queried the staff here. Some of those recommendations made it to the list, and I apologize in advance if any of them are poor, because I did not give them. But with that said, welcome. I'm sure this is going to be great, and look forward to hearing the panelists. And I'll pass it on.
All right. Good morning, everyone. I just want to thank everyone for being here virtually and in person. I'm Mark Ellion. I'm moderating today's Municipal Advisor Disclosure Obligations panel. I'm a senior counsel with the SEC's Office of Municipal Securities. I have about 15 years of municipal and corporate securities experience. Before I can introduce the topic and panelists more fully, I have to read the housekeeping items that you've already heard and will continue to hear everybody say throughout the day. The first is the standard SEC disclaimer. Just a reminder, the comments provided today by SEC staff participating in the outreach program, including Preston Swap, myself, and future SEC panelists, are provided in our capacity as staff of the SEC, but do not necessarily reflect the views of the Commission, the Commissioners, or members of the staff. I also have a press disclaimer. If there are any members of the press, we request that you do not attribute quotes or use direct quotes from any panels, panelists, or speakers in any articles or releases without first discussing and confirming such items with them. Also, please be sure to submit questions through Slido if you have any, and I will try to read them if I can figure it out. With that out of the way, I'm pleased to introduce my three great panelists to discuss Municipal Advisor Disclosure Obligations Day. Andrew Drew Kinsinger is a counsel at Hunton, Andrews, and Kurth, focused on federal tax and securities laws applicable to municipal bonds. Susan Gaffney is the executive director of the National Association of Municipal Advisors, NAMA, a position she has held since 2015. And Preston Swap is a senior counsel in the Office of Municipal Securities with about 15 years of municipal and corporate securities experience. And again, let me introduce the topic. It's an interesting one, for the Joint Compliance Outreach Program, Municipal Advisor Disclosure Obligations. It's interesting because I think a lot of municipal advisors don't know that they might have these municipal advisor disclosure obligations. It's something that we hear a lot and receive a lot of questions about. Also, there are many municipal advisor firms. They're performing a variety of different work. I've heard in some states that the municipal advisor does all of the disclosure. So that's really interesting, and I'm really looking forward to finding out where and how these obligations arise, how they become applicable to MAs, and some of the outcomes that can have if you don't, pay attention to your obligations. So with that, I'm going to kick it over to Drew with my first question. So can you please start us off by walking us through where, in a regulatory and statutory sense, these obligations come from?
Yeah, thank you. Good morning, all, and good to see so many friends in the audience and virtually as well. Many of you are watching remotely. For many municipal advisors, their role in the disclosure process falls into generally two camps. One is the camp where you're preparing and you're assembling and you're collecting and you're reviewing information that you provide into the disclosure process. There's another camp that is actually preparing the disclosure document itself. So across these varying roles that municipal advisors may play, there are varying disclosure obligations that emanate from these roles, and we'll talk about that for a few minutes here. Two overlays, though, that I want to offer you and think about as we go through this panel today. The first is that there's no bright line rule, there's no checklist type rule that tells municipal advisors, here are your disclosure obligations. There's no list like 15C212 of 16 duties that a municipal advisor has to check off its list, like material events. So we won't be able to offer you a bright line rule today, but we'll be able to, I think, provide you with some pretty good guidance based on SEC authority. Secondly, I think there is a good consensus on our panel in our preparation calls that whether you're a municipal advisor or any kind of transaction participant in a working group in connection with the offer and sale of municipal securities, you're doing so under the anti-fraud provisions. Section 10B, Rule 10B5 of the 34 Exchange Act, Section 17A of the 33 Act. And I think there was a consensus in our discussions that municipal advisors and other transaction participants have a duty under these anti-fraud provisions to identify information that they know is incorrect or that they should know is incorrect. The old corporate securities adage, you can't play ostrich and stick your head in the sand. If you are aware that there is incorrect information or you should be aware of it, you want to always keep in mind that the anti-fraud provisions are the template that municipal securities function under. So let's turn for a moment to the touch points, the pieces of guidance we have that could help us understand disclosure obligations of municipal advisors. In 1988, when the SEC proposed Rule 15C212, and a colleague of mine keeps a calendar, he says that anyone practicing in municipal finance under the age of 54 or 55 has never known a world without 15C212. But there actually was a municipal securities world before 15C212. And in 1988, the SEC proposed Rule 15C212 after the Washington Public Power Supply System defaults. And accompanying the proposed rule was an interpretation of underwriter responsibilities and other responsibilities of transaction participants in offering municipal securities. And there was a footnote in the proposing release that said when financial advisors associate themselves with an offering and participate in an offering process, particularly a competitive offering, they may have a comparable obligation under the federal securities laws to that of underwriters to inquire as to the completeness and accuracy of disclosure and to ensure that in the bidding process, the disclosure is accurate disclosure. Specifically, they said, look, financial advisors, where you have access to issuer data and you're participating in drafting the disclosure document in a competitive offering, you've got a comparable obligation to the obligation of underwriters. Now, there was a little press back on that notion. in the proposing release? What if you were a municipal advisor that was advising that you weren't participating in the preparation of the disclosure document itself? And I can hear Susan whispering in my ear, financial advisors, municipal advisors have a privity contractual arrangement with issuers, but when it comes to disclosure, the underwriter has the relationship with investors for good disclosure. But at least the SEC had put out there that they see potential disclosure roles and responsibilities with financial advisors. Now, after Rule 15C212 took effect, the balance with Rule 15C212 was a reasonable market rule that would be combined with responsible enforcement efforts by the Commission to ensure that there was compliance in offer and sale of municipal bonds. And so in 1996, we had a first municipal enforcement action. It was the Maricopa County action, Maricopa County being the county in which Phoenix sits. And this particular enforcement action focused on the role of a longtime financial advisor to Maricopa County. Maricopa County had completed their 92 financial statements, June 30, 92. They were going to market in June, July of 1993. After the financial statements of 92, the county started incurring financial difficulties. The medical enterprise fund was running at a deficit. They went out and tried to do a trans issue in late 92 and in late 93 rather, and experienced a downgrade rate. So they decide that they're going to go to market in 93, right after the close of the fiscal year, but no audited financial statements yet. And they went out without disclosing that there were negative trends in financial performance of the county. And the SEC looked at this situation and they concluded that the financial advisor was acting pursuant to an agreement that it would prepare offering documents that would contain complete financial and other data. That was the language in the record. But the Commission concluded in that enforcement action that the financial advisor had, in fact, recklessly failed to cause the omitted facts to be included in the disclosure document. That the financial advisor participating in that process knew of the negative financial information, did not encourage it to be included in the disclosure in the 93 offering documents, and so they were reckless in their failure to cause the omitted fact to be disclosed in the offering document. Taking that unique twist of words and putting it into plain English, I refer to this as the TSA enforcement action. If you see something, say something. They sanctioned the financial advisor under 17A, the anti-fraud provisions. They assessed a financial penalty, but this was a case of a financial advisor who knew of negative financial information, did not encourage that to be included in the offering document, and hence the enforcement finding. So interesting when you read and reread the Peacock-Hislop Maricopa County case. It has so many shades of the current Rochester case. Financial advisors involved in a situation where allegedly there was negative financial information that was known or should have been known and wasn't disclosed to investors. Okay. So after Maricopa County, we go to what I refer to as two bookend enforcement proceedings against financial advisors. The first is in 1999, County of Nevada, California. This is the era of Mello-Roos dirt bond deals. Single property owners taking over dirt tracts and developing through the issuance of tax increment type bonds, Mello-Roos type bonds. And in this particular case, County of Nevada, the financial advisor executed a contract with the issuer. And pursuant to this contract, the financial advisor agreed to prepare the POS and the OS describing the economic and financial background of the property owner in accordance with the disclosure required by Rule 15C212. So it wasn't a very artful way of saying, I will help you with your disclosure. She was very specific about she would prepare the disclosure document. This went before an administrative law judge at the commission, and the administrative law judge found that because the financial advisor had assumed the procedural task of preparing the official statement, she assumed the substantive responsibility of conducting due diligence and in fact had a duty of disclosure to the investing public. Quote, the financial advisor and the issuer executed a written contract that required the financial advisor to prepare the offering documents, and thus the financial advisor assumed the underwriter's responsibilities under Rule 15C212. And she was held to be primarily liable for anti-fraud provisions because of that written contract, written engagement with the issuer. When I think about this case, I suspect that it previews or is a precursor to what may be current views of the Office of Municipal Securities over at the Commission now, that if disclosure services are described as part of your contract with your issuer client, then it is likely municipal advisory activity and going to be subject to fiduciary type standards. But let's contrast that with the next enforcement action that came in 2005, and this is a fun one. This is an enforcement action that many of us regard. The old saying goes, bad facts make bad law. This was a case where many of us think perhaps bad facts made good law. It's the Dolphin Bradbury case, the office building in Pennsylvania that was occupied by the state, and they were acquiring the office building, and they were refinancing the office building with tax-exempt bonds, and the parties to the transaction, the underwriters and the financial advisors and others involved, knew that the state was going to be leaving their significant lease on this office building in 3 years or less, and that there would not be revenue sufficient necessarily to pay the debt unless the prospects of new revenues were found. And that ended up not being disclosed. And this is a great teaching case that Dave Sanchez and I have used to teach about material omission. The fact was omitted that there may not be revenue sufficient from this office building to pay debt service on the bonds. But as to the role of the financial advisor in this case, it was a handshake deal. The administrative law judge reviewing this case said there was no, unlike the Horler County of Nevada case, there was no written contract between the financial advisor and the issuer. It was a handshake deal. And the administrative law judge says, based on the testimony, the handshake deal was the financial advisor would review the offering document. And the administrative law judge goes off on this riff in his decision. Well, what does review mean? What does the word review mean? It's not defined anywhere. But in any event, the administrative law judge looked at the offering documents, and the offering documents contain disclaimer. It said the financial advisor is not obligated to undertake and has not undertaken to make an independent verification or to assume any responsibility for the accuracy, completeness, or veracity of the disclosure in the official statement. The financial advisor is an independent advisory firm and not engaged in the business of underwriting. We're not an underwriter. And the administrative law judge looked at this and concluded that that disclaimer language in the offering document limited the financial advisor's role or responsibility in the disclosure process. That in fact, the financial advisor was under no duty to speak to the issuer or to investors about disclosure deficiencies in the offering document. So the one case, County of Nevada, Horler, you have a written contract and the financial advisor ends up on the receiving end of an anti-fraud violation. In the next case, you have a handshake deal, no written contract, no writing except the disclaimer in the official statement, and the administrative law judge concludes no liability of financial advisor. Now, very interesting. The judge, James Kelly, in this Pennsylvania case said, but if the commission had appropriately made the case that there was a fiduciary duty that the financial advisor owed to the issuer, the outcome of this case might have been different. I may have well concluded that the financial advisor had a disclosure to speak to the issuer about deficiencies in the disclosure and speak to the investors. But he said the commission and the experts just calling the financial advisor a fiduciary was just bootstrapping. You can't just call someone a fiduciary and assign liability. You've got to establish a principal agent relationship. Well, that brings us forward from these enforcement cases, which are a little bit all over the map about duties and responsibilities of financial advisors. Of course, in 2010, Dodd-Frank adopts a provision to the Exchange Act, 15B, and adds the concept of municipal advisor and assigns to municipal advisor a fiduciary duty role. So what the judge could not find in the Pennsylvania case, Congress took care of in the Dodd-Frank Act. And so now, consequently, the roles and responsibilities of a financial advisor are those of a municipal advisor under municipal advisor rule from the SEC and rule G42 from the MSRB that talks about the roles and responsibilities of non-solicitor municipal advisors. So we work with a proposing release, we work with 3 different enforcement actions, and finally we end up with Dodd-Frank and the definition of municipal advisor. Now, just briefly before I turn this over to Susan, it was so interesting in the development of Rule G42 that in a first draft, they contemplated that in the duty of care that a financial advisor owes to its issuer client in the disclosure process, that a municipal advisor has to make a thorough review of the POS and the OS, that's just part of the duty of care. There was some press back on that first writing, that first draft of the rule, that might be too broad because municipal advisors may have engagements that don't include participating in the disclosure process. So isn't it a bit of a stretch to say that they have to thoroughly review both POS and OS? In the final version of duty of care under G42, it says that the duty of care extends to any information provided to the issuer client in connection with the preparation of an official statement for any issue as to which the municipal advisor is advising. So that narrows the scope a little bit. I will leave it at this. Reading the enforcement actions and G42 and the SEC municipal advisor rule all together, I think that where we're at is that if a municipal advisor contracts with an issuer client to prepare an official statement, then that municipal advisor may well have a duty to exercise care in the preparation of that official statement and to conduct due diligence to make sure there's a reasonable basis for how it is advising the issuer in that process. I don't want to forecast. I would guess this may be a next enforcement action to come, how duty of care for the municipal advisor extends to the disclosure process itself. But that's the framework, that's the background. Now, Susan will rein me in and say, that's great framework and great theory, but here's reality.
Right, so Susan, we're going to switch to you. So often there are questions, concerns from market participants about these obligations, specifically, how are they applicable? As the representative of NEMA here, I'm hoping you can address how these obligations may rise and what actions or activities might a municipal advisor do that could potentially result in disclosure obligations.
Well, thanks, Mark, and thanks to the SEC, FINRA, and the MSRB for inviting me. So as Drew pointed out, there's some gray area here, and most of what we know about MAs and disclosure exists in enforcement activities, both in the past and post Dodd-Frank world. But in these gray areas, I would say, let's first talk about what we know as certainties. As Drew said, like all deal participants, MAs must abide by anti-fraud rules. See something, say something. That is absolute. But it's really also important to know that MAs are service providers to their clients, to issuers. The Dodd-Frank Act regulated MAs to protect issuers. They face their clients and perform services that are agreed upon between the issuer and the MA. They are not market-facing, as you mentioned, like underwriters are to investors. Also, disclosure work in and of itself is not MA activity. Certainly, there are plenty of parties who do a lot of disclosure work and they're not registered MAs. But if the MA does provide advice or recommendations to clients on disclosures, then as Drew mentioned, that likely triggers the fiduciary duty standards under the MA rule and under MSRB Rule G42. Would also mention that in the FAQs to the MA rule, number 6.2, it specifically states that if a market participant is using general information that does not include a recommendation related to disclosure, then it is not MA activity. And I'll get back to that, but that is specifically in the FAQ. And also what's really important, of course, as we've seen all sorts of regulations on the MA world, the issuer needs and the services provided by MA firms differs significantly across the country and firm by firm. And the SEC and the MSRB have acknowledged this as they have written all the rules. For instance, in Minnesota, many deals are competitive and issuers contract with MAs to prepare the OS. And that is an accepted practice, even by bond counsel in Minnesota, whereas in other areas of the country, that would be absolutely unheard of. So while there are these certainties, let's talk about the great number of uncertainties that exist. As I just mentioned in 6.2, by the way, what is general information? That's not really explained in the FAQ, but if you are just using general information, then it is not MA activity, but that is not defined. If an MA does include disclosure work in their MA contract, then it is likely MA activity. And the question is, even if that MA is not providing a recommendation, not providing advice, but yet puts it in their contract as an MA service, then is it automatically an MA activity with the duty of care and the federal fiduciary standard applied? There are a lot of words that people use to describe what MAs may be doing to help their clients with disclosure. Compiling, scribing, drafting, preparing, active role in preparing, participating, reviewing. All of these have different meanings to different firms. And we would probably argue also to SEC examiners who may interpret these words very differently than the people who use them. So it's not clear right now if the SEC believes that if an MA touches disclosure, using any of those words or others, then are they taking on responsibilities that are not clear to them and are greater than once thought of? And then what does it mean to have that duty of care and the fiduciary duty applied to the disclosure work of the municipal advisor? What again, if that is only administrative tasks? So that is also a really interesting question because one can argue the duty of care and suitability and understanding when they're making recommendations or advice on a transaction. But when it gets down to this granular level of disclosure, then explain how that applies and how an MA, what they need to do in order to comply with that. It's really important that MAs are clear and focused about their work in their contracts, the extent of their work, the limitations of their work, and if they are including this work as an MA activity or an other activity that they're providing their client. This is especially true in an exam situation where the examiner may look, well, I see you providing these MA activities, then you have other activities. Understanding where and how MAs should be creating those sort of bifurcations within their contracts or separate contracts, and how the examiners are looking at that, and can they look at those other services within the exam to see if they believe it should be considered an MA activity. Those are all outstanding questions as well. And then if an issuer, or if an MA is helping an issuer with their disclosures, it does not negate the role of bond counsel and disclosure counsel, who are providing advice and really providing that advice to their clients from a legal perspective. So any work that the MA does is not there to negate or conflict with counsel. And GFOA's best practices speak mightily about the important role counsel and disclosure counsel plays to an issuer. Again, at the end of the day, the disclosure documents are the issuer's documents. Again, in the offering statements and continuing disclosures, wherever the MA may be helping to prepare or assemble these documents, there's still the important role of counsel, and that should also be referenced here. So there are a lot of these uncertainties. I would argue those uncertainties, while the number of them may not be as many as the certainties, there are a lot of gray areas there that we could go in a lot of different directions. So how should MAs and the community and the SEC approach these uncertainties? Well, the MAs must be really careful and focused, as I mentioned, in their scope of services as to the work they are doing and how they portray that work and what they're not doing, and making sure they have the adequate disclaimers in the OS. Now, this doesn't mean that if you do provide that service but don't put it in the contract, you're being cute and you're not held accountable. That, of course, never works, but you need to be accurate in what you are doing. So MAs may wish to consider the extent of their disclosure work and how they portray that in these contracts and in the offering documents, and whether they should be listed as MA activity or other services. And perhaps consult counsel on that discussion and be sure that the client understands their scope of work. Again, you don't want the client believing, oh yeah, Jim was handling this and my bond counsel Jane was doing that. You have to make sure that the client also understands what you are doing. And so that since there's no uniform, as you mentioned, no uniform regulatory understanding of this part of the world, making sure the client knows who's doing what is imperative. And it's just vital, I can't say it enough, that the contract really speaks to the type of work and those are carefully articulated. MAs need to understand the liabilities that could be associated with disclosure work, including anti-fraud, 10b-5 standards, and Rule 17a, which does not have an intent trigger, and I know we'll talk more about that, as well as the duty of care and the fiduciary duty implications. And of course, MAs need to consider how their disclosure work, especially if it's considered MA work, is addressed in their WSPs. What are the policies and procedures related to that? What can you be able to show the examiner of how you're thoughtful on this and where you have the correct policies and procedures in place in order to engage in these kinds of activities? And more importantly, the SEC should consider adding more FAQs on this matter, since there are a lot of gray areas in all of this. So I'll just conclude by recapping again, the anti-fraud rules always apply and are very important, and MAs need to be very well aware of that. That disclosure work in and of itself is not MA activity, but that MA is providing services to issuers as determined by MA and the issuer needs to determine what that line is and what types of work they're doing if it is related to disclosure, and as well as all other aspects of their contract, and being very specific in that contract. Providing advice or recommendations related to disclosure is likely a trigger for G42 and fiduciary duty obligations. And MA should have specific procedures on how the firm labels and conducts its disclosure work, especially when exams may ask this question and address that in their WSPs. And really more importantly, again, we hope that the SEC could say more on this topic of MAs and disclosures. And this is especially needed when on a greater level, the understanding of MA activity has become more uncertain than when the MA rule was finalized 10 years ago. The conversations I've had with many of our members, there's a lack of confidence in knowing what the SEC's view and scope of this term, municipal advisory activity, is, not only related to disclosure, but many other issues as well. And Preston, if you want more information on that, I'll just text it over to you.
Thank you. Just some, a few pragmatic takes or add-ons to what Susan was talking about that we encounter in practice. Always, every new issue is a new and good occasion to revisit your engagement letters with your issuer clients and see how it discloses your role and disclosure responsibilities in the POS and OS process. look, I understand on the legal side, we have long-standing bond counsel relationships with issuers, and we hate to go back and ask for a new engagement letter on each and every offering. We like to say, well, we've been working with this issuer forever. We don't need to revisit the engagement. But always a good practice, given these uncertainties under the MA rule regime, to see how you're describing as a municipal advisor your roles and responsibilities in the disclosure process. Secondly, and there is some authority from the SEC, I always think disclaimers are a good thing. Disclaimers in an engagement letter, disclaimers in the text of the offering document, disclaimers in closing certificates. Be on the lookout when you get into these working groups. You've been on the checklist calls, and a council or two councils will ask for 10b5 certificates from everyone that's on the distribution list. Should you, as a municipal advisor, be signing a 10b5 certificate? Is that consistent with your role and responsibility in your engagement or not? So I spend a lot of time with clients parsing, frequently asked question 6.2 on what is merely compiling information to help an issuer with disclosure or assembling versus what is recommending to the issuer what they should include in their disclosure or how they should say it in their disclosure. I think that's a key distinction. And finally, just one practical note, because this comes up so often. Let's say you have an engagement with an issuer that's silent on your disclosure roles or responsibilities as a municipal advisor. The question is always asked, well, if I'm on the distribution list or if I'm in the working group, does that mean I'm a municipal advisor with a fiduciary duty for the disclosure? Probably not, but remember again, as Preston will pick up on, that if you are on a working group list and you're a participant in the offer and sale of municipal securities, you're doing so under the anti-fraud provisions. So.
And let me just say, when you talk about engagement letters, a lot of MAs and clients have engagement letters that have existed for a long while because the issuer's procurement process is one that you're not, re-engaging every year. And so I would still argue it's still important to look and see what that language looks like. It could be 5, 7, 10 years old. And again, look at the services you're providing to see if it's accurately portraying what is an MA activity and what is not.
All right, so I have a question for Preston, but I just also want to note for Dave that there was a request for FAQ, so there you go. Preston, so we have discussed the background, history, and applicability. Why might MAs need to take municipal disclosure obligations seriously from a guidance compliance standpoint? And what are some compliance concerns municipal advisors should be aware of?
Okay, thanks, Mark, Susan, and Drew. It's a nice and powerful microphone. For good measure and to everyone's annoyance, I'm just going to repeat that my comments are provided in my official capacity as Senior Counsel of the Commission's Office of Municipal Securities, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. You're going to hear some recurring themes, which I think is good. We're all kind of focused on the same things. I'm going to focus, like Mark said, on why I think it's important to consider a municipal advisor's role in disclosure and to take any such role seriously, as well as mention some related compliance considerations given the conference's theme. I know we're a little short on time. How much do I have, Mark?
Just a little under 3 minutes.
Okay. So one reason to take an MA's role in disclosure seriously is the anti-fraud provisions that we keep hitting. Those are Securities Act Section 17A, Exchange Act Section 10B, and Exchange Act Rule 10B5 thereunder. Generally, the anti-fraud provisions of the federal securities laws prohibit fraudulent or deceptive practices in the offer and sale of municipal securities. And among other things, these anti-fraud provisions prohibit any person from making a false or misleading statement of material fact or omitting any material facts necessary to make the statements made by that person not misleading in the connection with the offer, purchase, or sale of any security. So note that an MA is subject to the anti-fraud provisions in the same way as any other person. And in other words, the anti-fraud provisions apply even outside of a municipal advisory relationship and any fiduciary duty owed to the municipal entity client. An MA may be liable for material misstatements or omissions in a disclosure document if the MA has actual knowledge of such material misstatements, or omissions and does not take actions to ensure adequate disclosure. And prior SEC enforcement actions have found MAs both primarily liable and under the anti-fraud provisions and liable for aiding and abetting violations under the anti-fraud provisions. And it's also worth noting that while some of the anti-fraud provisions require an element of scienter, others do not, namely Securities Act Section 17A2 and 17A3, in which case negligence may be sufficient for liability. And Section 17A2 is the provision about false and misleading statements. In addition to the general anti-fraud provisions applicable to all persons, I also wanted to note that the Dodd-Frank amendments to Section 15B of the Exchange Act created an anti-fraud provision specific to MAs engaging in municipal advisory activities. This provision prohibits any fraudulent, deceptive, or manipulative act or practice while engaging in municipal advisory activities on behalf of either a municipal entity or an obligated person client. As a result, if participating in the preparation of disclosure is municipal advisory activity and within the scope of an MA's relationship with the municipal entity client, this provision may provide an alternate legal basis for liability. And again, another reason to take an MA's role in disclosure seriously is the existence of the fiduciary duty. And there's a whole separate panel on statutory fiduciary duties, so I'm going to limit my comments here. But everybody here knows that an MA owes a fiduciary duty to its municipal entity client. And while an MA does not owe a fiduciary duty to its obligated person client, it does have other obligations under MSRB rules to such clients, like fair dealing under MSRB Rule G17 and a duty of care under MSRB Rule G42. So the statutory provision itself regarding fiduciary duty notes that a municipal advisor and any person associated with such municipal advisor shall be deemed to have a fiduciary duty to any municipal entity for whom such municipal advisor acts as a municipal advisor. And no municipal advisor may engage in any act, practice, or course of business which is not consistent with the municipal advisor's fiduciary duty or that is in contravention of any rule of the board. I think it's also probably worth briefly touching on that municipal advisory activity includes an advice component where the municipal advisor is providing advice to or on behalf of its municipal entity client with respect to municipal financial products or the issuance of municipal securities on a matter that is related to advising on structure, timing, terms, or other similar matters. So not all services by a municipal advisor constitute advice. And a municipal advisor's participation in the preparation of disclosure documents may constitute advice because, in my view, because structure, timing, terms, and other similar matters are frequently described in the disclosure documents, such as preliminary and final official statements. And participation in the preparation of disclosure documents is one way in which a municipal advisor might convey its advice to the municipal entity client on such matters. And in such a case, the municipal advisor's fiduciary duty would attach to such participation. Additionally, the MA rule adopting release states that MAs engage in municipal advisory activities in a variety of contexts. And with respect to the issuance of municipal securities, municipal advisors may, among other things, ensure adequate disclosure. And this permissive language is consistent with prior cases like public finance consultants, where an MA was found not necessarily required to undertake specific disclosure responsibilities. So the scope of an MA's relationship with this municipal entity client can be determined either through an MA's agreement with its municipal entity client or through municipal advisory activities actually undertaken. And as Drew and Susan have alluded to, prior cases and just general practice shows that the scope of this relationship can vary greatly. And also, Susan noted that that An MA may at any point define the scope of the relationship with its municipal entity client, and thus the corresponding fiduciary duty to include disclosure-related obligations that constitute municipal advisory activity. Again, this can occur through an agreement with the municipal entity or through municipal advisory activities actually undertaken. And in construing the nature of an agreement between an MA and its municipal entity client, I think it's worth noting that generally the prior administrative cases have looked to the terms of the agreement and determining the particular obligations of a municipal advisor with respect to a disclosure document. But when such an agreement is not available or does not clearly address the municipal advisor's level of participation, administrative law judges or others, might look to a municipal advisor's course of dealing. For example, in the Public Finance Consultants Inc. case, as Drew had mentioned before, the administrative law judge reviewed the history of the municipal advisor's relationship, the parties' actions, and disclaimer language to determine the scope of the agreement, because the agreement was just based on a handshake. So in the absence of a written agreement or in an agreement with gaps or ambiguities, I think it's worth considering that the course of dealing might be looked at in construing such an agreement. It's also just good practice to, if you're changing your practices from what you generally do for your client, you should I think you should let them know. So to switch gears a bit, a compliance-related item I'd like to mention, what Susan also brought up, is the written supervisory procedures or WISPs under MSRB Rule G44. And I'm going to limit my comments on MSRB rules, but I'm just going to note that the rule states that each municipal advisor shall establish, implement, and maintain a system to supervise the municipal advisory activities of the municipal advisor and its associated persons that is reasonably designed to achieve compliance with applicable securities laws and regulations, including applicable MSRB rules. As a result, to the extent an MA is engaged in disclosure-related activities that constitute municipal advisory activity, then an MA might consider reviewing its WISPs to determine if those WISPs satisfy MSRB Rule G44. And so to keep time for questions, I'm just going to kind of sum it up. And again, we're hitting similar themes here. But the last item I wanted to discuss are some thoughts about best practices in my view. I won't really say much, if anything, new here, but I wanted to revisit some of what we've already discussed. We've talked about defining the scope of the MA's municipal advisory relationship with its municipal entity client, and municipal advisory activities that are actually undertaken. We've mentioned WISPs. And a theme I think that emerges from this is that and Susan touched on this, and Drew as well, is that it's important to understand and define early on in the process what, if anything, an MA is planning to do in the context of disclosure. And I think making that as clear as can be made to both their client and the working group so that everybody's on the same page. Because when that's not clear, I know from my prior practice in private practice, it's not fun when people are fighting over territory at the last minute. So taking care to define this early on can avoid headaches and awkward situations later on. And so with that, that's all I have.
Just as a practice follow-up to Preston's presentation, if you're a municipal advisor and you're in disclosure land, preparing, helping, assembling, recommending, advising, where you may be under G42 and you may be under duty of care and looking at duty of care, always good to revisit your WISPs. Enforcement proceeding after enforcement proceeding. There's been a clear message that if a target has a set of disclosure policies and procedures that they have implemented and that they're following, that's almost like a pre-remedial first step of cooperation with the commission, that we knew we were engaging in course of conduct or actual municipal advising in the disclosure process. And with respect to that, we do under G44 template have a WISP in place that addresses what disclosure activities we may be undertaking. The presence of that WISP and updating that WISP is very helpful in the exam or enforcement process when you're the target and we're defending you. It's just the perfect, opening volley to say, well, enforcement, our client has a good set of disclosure policies and procedures and a course of dealing where they're following them in their disclosure work. That's always a good place to start from.
So just before we wrap up and jump into the Slido questions, because we do have a few and we saved some time specifically for that. Thank you again to Susan, Preston, and Drew. So it sounds like in some form going back to the common law and 1998 SEC release and following through case law, Dodd-Frank, the adoption of the municipal advisor registration rule, a municipal advisor could have these disclosure obligations. And then these disclosure obligations may be applicable to municipal advisors if the municipal advisor agrees contractually. And I think Susan would want to say be clear about your contracts, to having a disclosure role or engages in a municipal disclosure activity, which is a less clear area. And then, there's the anti-fraud statutes are applicable. See something, say something of municipal disclosure liability. And that can apply in lots of different realms. But, if there's fraud or a fraudulent omission and you're an MA working the deal, it's something that you should be aware of, that you may have this anti-fraud liability. And then finally, municipal advisors that find themselves regularly engaging in municipal disclosure activities should have WISPs and should make sure that they're complying with MSRB Rule G44. With that, I'll switch to some of these questions.
Yeah.
So one of the ones that came in is, if an MA fiduciary duty is to the client, not investors, how may an MA consider situations where a client may not follow the advice regarding an OS?
Yeah, one can never completely control a client's actions or inactions, particularly when we're dealing with local governments, school boards, cities, townships, development authorities. I mean, there's always going to be a range of practice in the best of all worlds, and I'm not talking legal services here. If I'm a municipal advisor and I've got a contractual relationship with an issuer and I'm advising the issuer about certain aspects of the disclosure, but the issuer is choosing to go a different direction or handle the disclosure in a different manner, I would take a lot of comfort as an MA if there was a disclosure counsel to the issuer at the table. And I know that their disclosure counsel presence on behalf of issuers is an increasing role. I also hear from some municipal advisors that our longtime issuer clients sort of say, well, why do we need a disclosure counsel when we have you? Okay, which again puts some real pressure on, make sure you know what you're saying in your engagement letter, and encourage, if you have an issuer that's saying, thank you, municipal advisor, I understand your recommendation and advice, but I'm also listening to the underwriters over here and the bond counsel over there, and so I think we'll phrase this sentence differently. I know you think we should be saying more, but I'm going to say it this way. That's one where you say, okay, it would be nice to consult with your disclosure counsel on that point and to rely on their opinion, because here's the scope of our engagement. And also, keep a written record, of course.
Well, that's exactly. I mean, the MA is with any decision that they're recommending, and then if the issuer doesn't follow that, be sure to document that.
All right, another one. What is the underwriter's responsibility for content of a continuing disclosure agreement, specifically the extent of the items to be included in annual filings? So that's a little bit of a off-topic pivot.
Yeah, that's, when you get into continuing disclosure land, first of all, an underwriter is there at the primary offering point. and the underwriter and its counsel are reviewing the continuing disclosure undertaking. They want to make sure the POS is deemed final. They want to make sure that they have a good disclosure undertaking. Oftentimes they look to their underwriter's counsel to say, this is a good continuing disclosure undertaking under the rule. But you also have the financial advisor who's involved in the continuing disclosure process as well. And there was the Oklahoma case in 2017 where the issuer, on advice of a now retired bond counsel, was making amendments to its continuing disclosure undertakings that were in existence. And the financial advisor who was at the table advising the issuer on continuing disclosure wasn't necessarily tracking that those amendments were done in sync with prior guidance from the SEC on what continuing disclosure amendments are permissible, and also wasn't informing through the EMA process on behalf of the issuer the fact that these continuing disclosure undertakings have been amended and you're not necessarily investigating the same information you thought you were at the time of the original undertaking. And at the end of the day, the commission found that this financial advisor had, with respect to the continuing disclosure advice, breached its fiduciary duty to the issuer. It was really the first breach of fiduciary case under the municipal advisor rule, I think, that came out in the continuing disclosure context. So, look, if you have an underwriter who is at the primary point and reviewing the undertaking, and in the underwriting period, making noise about this is different, we need the sticker, we need to fix the offering document, we need to get a supplement out. But then the underwriter, sort of disappears from the process, and you, the municipal advisor, are still at the table with the issuer, advising on continuing disclosure. And again, this is where, be careful in your contracts. If you're just compiling information for the issuer and you're prompting the issuer client to say, oh, your filing deadlines are coming up, or, you had a rating change, you better get that filed with EMA. Those are not recommendations. They're not advice per se. They're factual matters, right? There's no materiality decision about those rote requirements. But if, you're advising your issuer client that we think this may be a material item for an event notice, or we think you should make voluntary disclosure to the secondary market through EMA about this change, then you are in advising and recommending a municipal advisory and fiduciary land. So, the underwriters carry it through the primary and end of underwriting period, but municipal advisors oftentimes stick with their issuer clients on continuing disclosure. Some do it by separate contract. Some just include it in one contract. But again, it just points to the importance of, if you're doing continuing disclosure work, know how you describe it in your engagement letters.
We have another one that I'll just take myself. It's, will you be publishing a transcript of this event, and where will that be made available? I'm not sure that we'll be publishing a written transcript, but the videos should be posted. They'll be posted at sec.gov under the outreach program page, and we can circulate that information when it becomes available. And I think we only have time for one or two more, even though there are a lot in here. So there was a mention of distribution lists and how that could potentially raise anti-fraud liability. Could being on a distribution list with 100 people, if you never do anything disclosure related, really raise anti-fraud liability?
I don't think so. I mean, I'm just being pragmatic about practice. We get these distribution lists that include half of the free world, right? And contra, on the other end, and without disclosing too much detail, but anecdotally, I had an issuer client who received a subpoena from the commission. Really, under the order that we obtained, they were seeking factual information about a party other than the issuer. But in the enforcement process, which can be a very expensive and time-consuming process for an issuer, for a municipal advisor to the issuer, for anyone involved, but they were going through the distribution list and they were trying to isolate why were certain people at the meeting did anyone know who these people were at the meeting or what function they were providing? And in the end, they found that this was basically an unregistered municipal advisor type who actually had prior SEC sanctions against him, banning him from participating in the offer and sale of securities. But it took a while for the commission staff to, and they were very methodical and detailed in doing so, going through every party on the distribution list. One piece of testimony, who drove this person? Who drove this person to that meeting at the city hall? And so when you're on a I think the important point about distribution lists is if you are participating in the disclosure process, you're doing so under the ambit of the anti-fraud provisions. And if you are unregistered, which is a whole nother topic, and you're providing municipal advice, you've got some exposure under the MA rules. But the old adage goes, know who you're dealing with. Know who's in the room, and if you see something that is not making sense, you say something. Now, we all get, when an issuer is going to release a POS or do a launch for a tender, everyone on the distribution list says, okay, we need sign-offs from everyone before 4 p.m. today so we can release this to Muni OS. And they come back and say, we have sign-offs from everyone except A, B, and E. And we're waiting for sign-offs. Well, the question comes, by signing off on the POS, am I participating in the disclosure process, and do I have liability? I mean, again, facts and circumstances, course of dealing. On behalf of our client, we're okay with a POS. You may even add something that we didn't participate in it, but okay with us. A disclaimer may be appropriate, but by and large, mere presence on a distribution list, I don't think triggers 17A or 10B or 10B5 or G42 or MA rule, unless you are playing a meaningful role in the disclosure process, and then you want to be very aware of your duties. That's just my pragmatic advice.
All right, with that, I think that we're almost up to our time. We're going to head to a 10-minute break. Thank you very much.
Good morning or good afternoon. The folks points east. This is the second panel for today on off-channel communications. I think we have a really great panel today. I'm really excited. I'm going to do some brief introductions for folks here on the panel, but first I will go ahead and make the disclosures for the SEC panelists. The comments made are provided in the panelists' official capacity as staff members of the commission, but do not necessarily reflect the views of the commission, the commissioners, or other members of the staff. And for anyone from the press who may have missed the disclosure this morning, if there are members of the press, we request that you do not attribute quotes or use direct quotes from the panelists in any articles, publications, or releases without first discussing and confirming such items with the panelists. So again, I think we have a really great panel. I can't imagine how we could put together a better panel on this topic. It's timely, and I think it's of great interest to a lot of folks listening here. So I'm going to start at the end of the table. Rebecca Olson is Deputy Chief of the Public Finance Abuse Unit in the Division of Enforcement at the SEC. She previously was Director of the Office of Municipal Securities at the SEC and was previously a public finance attorney in private practice. Following her is Bill Downey. Bill Downey is a manager in the fixed income specialist team at FINRA. They focus on fixed income exams. And previously he worked as a trader on both sell side and buy side firms in the muni market. Next we have Dave Sanchez. Dave Sanchez is the current director of the Office of Municipal Securities. This is his second stint at the SEC. Previously, he worked in a number of the projects at the SEC coming out of Dodd-Frank for standing up the some of the muni market reforms coming out of Dodd-Frank. He's also served as general counsel to an investment bank, deputy city attorney for the city and county of San Francisco, and a public finance attorney in private practice. And immediately to my left, Bree Joyner is the Senior Director, Market Regulation at the MSRB. She's the lead advisor to the Chief Regulatory and Policy Officer at the MSRB. And she also serves as a member of the MSRB's Retirement Plan Investment Committee. She previously was at FINRA in their Office of General Counsel, as well as their Member Education Department. And before that, she was at the SEC working on issues related to broker-dealers. So I'm going to start off, we're talking about off-channel communications, and maybe I can throw this first to Dave. What are the obligations that folks in the market should think about when we think about off-channel communications?
So, I mean, the first primary consideration is what are your books and records requirements? And, you know, despite a lot of discussion about it, I might let Bree handle the broker-dealer ones in more detail, but despite a lot of discussions about it, the books and records requirements for municipal advisors and broker-dealers are really relatively simple and straightforward at their core. Bree, I don't know if you want to go into more detail as to.
Sure, I'm
the
happy
wording.
to.
Yeah.
So let me just cover this. I will start with Rule G8, G8H on municipal advisor records. It does require municipal advisors to make and keep current, among other things, general business records. We go on to prescribe that those general business records are those that are required under 15 Cap B, A1 through 8 under the Exchange Act. We also go on to talk about those records that have to be made and maintained with respect to dealer activities. So under G8, the records covers Rule G27. What we state is that dealers have to make and maintain and keep current records related to Rule G27E. Now you may be asking yourself, well, what exactly does G27E state, considering I have to make and maintain that record? If you take a look at Rule G27 on dealership provision, Provision E specifically requires that with respect to supervision, that municipal securities representatives' correspondences have to be reviewed. It also requires that those records have to be made and maintained regarding municipal securities representatives' correspondence. So again, the rule particularly states that dealers must establish procedures for the review by a designated principal of incoming and outgoing written and electronic communications regarding municipal securities representatives with the public relating to the municipal securities activities of that dealer. So that kind of outlines the requirements with respect to dealer requirements, having to make and maintain and keep current records.
But fundamentally, right, it is, you're keeping records about your business, and both the SEC rule and the MSRB rule you stated say the same thing. For the SEC, it's you're keeping records related to your business as a broker-dealer. And that's essentially what the MSRB rule says.
That is true. That is true. A correspondence is considered a communication, a record that has to be made and maintained.
And then for municipal advisors, right, there's a list of things, but the ones that we're mostly talking about in terms of off-channel communications are communications related to municipal advisory activity. And that's communications that you may send back and forth to your client or anyone else that's related to municipal advisory activity. And then importantly, there's another provision that you have to keep records that may be just purely internal records that are material to the recommendations that you give. And so at the end of the day, you know, the core principles that we're talking about are not that complicated. It is frankly what is related to your business.
So is it right to think about, you know, the sort of legal standard for these obligations? How do we think about that? Is it, you know, sort of strict liability? Is there a reasonableness sort of gloss on this?
It's a really good question. I mean, and I think in a lot of discussion, you hear different viewpoints. And so, you know, you can think of the disclaimer that's been made 40 times already, a blinking red over my head. But in my view, it is reasonable, right? And this is what we're thinking about, a reasonable standard for the records that you're maintaining. And it can be really easy as a regulator to simplify, you know, the kind of tough decisions that you might have to make when you're in practice. So I think it is important for all the regulators in particular to remember, you know, like even though we have these words on a page and so relating to municipal advisory activity seems pretty clear, you will get into real life situations that are more difficult. But this applies across a lot of securities laws, and you'll hear this all the time. If you have a process in place, are you following that process? And is the process sort of inherently reasonable? You cannot account for every possible contingency, but you have something in place. That always goes a long way in helping you out. And so I've been surprised in some of the recent discussions when people say, I don't know what MA activity means. Because I'm like, really? I think you know most of what your job is. Like, I mean, it's pretty clear. We're talking about pricing. We're talking about, are we going to put a 10-year call on this or not? These things are very fundamentally your job. That's not to say that there's going to be some things where you might not have questions. There will be. But again, once you start building up a reasonable process, I think a lot of that answers the questions for you, but also is really helpful in any regulatory environment.
So you've gone over the rules, both from the SEC and from the MSRB. Are there any other places that the SEC or any of the SROs have put out guidance on these rules that folks can look to?
Yeah, so FINRA's put out a number of different guidance documents over the years, going back even to August 2011. Reg Notice 1139 issued some guidance on social networking and use of social networking and business communications. That was updated with Reg Notice 1718, issued in April 2017. It's kind of it's a dynamic and always updating area. So it's a place that we know that there's constantly guidance needed. More recently, the 2024 FINRA Annual Regulatory Oversight Report, specifically the Books and Records section, contains some questions that firms may want to review to kind of help them as they assess whether their own supervisory systems are reasonably designed to capture, supervise, and maintain off-channel communications. Additionally, FINRA's member supervision is in the process of developing guidance based on feedback received from member firms at 2023 roundtables that FINRA held, as well as the results of thematic reviews that FINRA's conducted and other observations that we've pulled in from sort of across our examination program. The idea is to provide this guidance to help support firms in strengthening their compliance programs. As you said, we're aware this is kind of like a dynamic, constantly updating area that people really need to keep abreast of. Bree, do you have some more guidance there?
I'm happy to jump in here. So the MSRB, we published around 2001 interpretive guidance that talked about the application of rules G8 and G9 with respect to record keeping. So some of those things that you'll find in that interpretive guidance goes over the tenets of basically what is required to be made and maintained. But I think it is helpful to point out what it also talks about is that there's flexibility with respect to your record-keeping systems. There are different ways in which basically you may capture information and capture those business records. And so it really is important to point out that we do not prescribe necessarily the prescription in which basically you're going to use and exercise, especially in the off-channel communications, about capturing those records, but there is some flexibility that's there. We also issued the Compliance Corner, which was in 2019. The 2019 Compliance Corner, again, just reminded firms, because we had been hearing quite a bit about obligations related to making and maintaining records, and that this was an area that we could raise greater awareness for the municipal advisors about the making and maintaining records, including general business records. So you will find that we outline that within that Compliance Corner and provide, of course, a couple of examples of what's considered general business records.
And the SEC, for its part, in 2017 and 2012, exams put out risk alerts where they raised the issue of, looking at folks' electronic communications process, and in particular, in some detail in one of the risk alerts, specifying text messages, other off-channel communications not being properly kept. All that to say, we understand that guidance is always helpful, and I think, realistically, FINRA and MSRB have more opportunity to provide guidance, but it's also true that the SEC rules are different, right? And the MSRB and FINRA are not going to necessarily provide guidance interpreting the SEC rules, although their rules will say you also have to comply with Exchange Act rules. So we understand that it's always helpful to have that communication, but I will also kind of remind folks that you're not going to be spoon-fed an answer, right? I think we've heard this enough. Like you have flexibility to design your program. Everything, there's a lot of things that are facts and circumstances, but it's also really important to listen when any regulator speaks, especially the SEC, because we do not have the opportunity to speak that much. And so when we say something, it is very thoughtful and it's really important. And so there has to be some part of a two-way street where, yes, it is continually important for something like this, rapidly changing technology, for regulators to speak and try to provide guidance, but it is also important for you as a regulated entity to be tuned into what the regulators say. And again, I will emphasize that the SEC does not have the ability to speak as much as the other regulators. So when we do say something, it is really important.
So I think that gives a good survey of sort of the obligations and some of the guidance out there and how the SEC has sort of approached, books and records, and then now kind of more recently off-channel communications. And so maybe we can go to Rebecca. Can you walk us through a little bit? So what has the SEC done recently with respect to what we're calling off-channel communications?
Sure. Well, since December 2021, the Commission's brought charges against more than 100 firms, including broker-dealers, investment advisors, municipal advisors, and credit rating agencies for failures to maintain and preserve electronic communications in violation of the applicable record-keeping requirements the panel was just discussing. The Commission has collected over $2 billion in penalties, with individual penalties ranging from $125 million to zero for a firm that extensively cooperated with the staff. The matters were all settled, administrative, and cease and desist proceedings, and the firms all admitted that their conduct violated the federal securities laws and began implementing improvements to their compliance policies and procedures. I mean, I think these cases demonstrate how seriously we take the record-keeping requirements on regulated entities, regardless of what type of registrant you are. Compliance with books and records requirements of the federal securities laws is essential to the Commission to facilitating our compliance inspection and examinations and our enforcement program. Put another way, when firms fail to keep records, we can't do our jobs. So the settled proceedings with the broker-dealer firms charge the firms with failure to maintain and preserve written communications relating to broker-dealers' business as such, the rules Dave was just discussing, Exchange Act provisions, and also failures to reasonably supervise personnel within the meaning of the Exchange Act, Section 15B. And while some of the broker-dealer firms that have been entered into settlements with the Commission are also registered with the MSRB, the SEC's enforcement proceedings did not specifically relate to their municipal business as such and did not involve MSRB rules, but the recent cases against municipal advisors did. So I'm going to spend a little bit more time on those today. So on September 17th, 2024, the Commission announced it had charged and entered into settlements with 12 municipal advisor firms for failure to maintain and preserve electronic communications. The firms were all identified as part of a staff risk-based initiative. The firms paid civil penalties of $1.3 million combined, with the highest for an individual firm being $250,000 and the lowest being $40,000. So the settled proceedings with the municipal advisor firms charged that they failed to maintain and preserve written communications relating to their municipal advisory activities in violation of Exchange Act 17A, Rule 15 Cap B A18, and MSRB Rules G8 and G9. They also were charged with failure to implement and maintain a system to supervise the municipal advisory activities of the advisor and its associate person that was reasonably designed to achieve compliance with applicable securities laws and regulations in violation of MSRB Rule G44. No individual employees were charged. And unlike the broker-dealer settlements, none of the firms were required to engage an independent compliant consultant, but each firm agreed to undertakings to establish reasonably designed policies and procedures regarding the preservation of electronic communications, conduct a training regarding the preservation of electronic communications, and also to establish going forward a periodic training program, and finally to designate a municipal advisor principal to be responsible for ensuring compliance. Just to give you a little bit of color about the actions, The key findings across all the matters were that over multiple years, employees at the firms communicated internally and or externally with clients by text message using firm devices or personal devices. The communications related to the firm's municipal advisory activity and were not retained as part of its books and records. At each of the firm's supervisors who were responsible for implementing the firm's policy and procedures routinely participated in the communications. And most of the firm's policies and procedures advised employees that they could not use text message for communicating with respect to municipal advisory activities because it wasn't captured by the firm's record-keeping system. Generally, the firms had a procedure for all employees where they would sign a self-certification of compliance with the electronic communications policy on an annual or more frequent basis, or they would give a written acknowledgement that they understood and complied with the firm's electronic communications policies. However, there was no follow-up on these certifications. So the firm just relied on them without doing any kind of follow-up to see if folks were actually complying. In connection with our investigations and settled enforcement proceedings, I'm sure as you all know, we got a lot of questions regarding what are written communications relating to municipal advisory activity. I mean, from my perspective, there is a lot of guidance on activities that are municipal advisory activities, starting with the Commission's adopting release from 2013, as highlighted by Preston in the first panel, multiple series of FAQs that have been put out over the years by the Office of Municipal Securities. And also, we now have over a decade of the Commission enforcing rules, the municipal advisor rules, including against firms engaging in unregistered municipal advisory activity. And all of those orders have examples of what the Commission's views are on what are municipal advisory activities. In our investigations, we certainly were not looking for messages regarding meeting up for a cup of coffee, messages regarding who's going to be on the screen for a Zoom call. We were looking for communications that actually related to municipal advisory activities. And we did include genericized examples, so we didn't want to identify people or their clients of these examples in each of the orders that the Commission found should have been kept. So some highlights from the orders for you are, there were texts between MAs and from MAs to clients about the structuring of an issuance of municipal securities, including whether to structure the issue as a fixed rate or variable rate deal, whether to issue on a tax exempt or taxable basis, the underwriter's coupon selection, and the MA's recommended changes, including by how many basis points they would ask the underwriter to make changes, the MA's recommended final maturity of the bonds. There were texts related to, from MAs to clients, about the method of sale for an issuance of municipal securities, including whether the client should do a negotiated deal or a competitive offering. There were texts between MAs and MA clients about the pricing of their bonds, including identification of oversubscribed maturities, the expected impact on the yield, and what maturities they were going to ask the underwriter to change the spreads on. There were also texts from MAs to clients about the credit rating or anticipated credit rating on their bonds and how that would impact pricing. If you are interested in more detail, the orders, along with all the other Commission's enforcement proceedings, are available on the Commission's website, and they're also very nicely organized on the Office of Municipal Securities homepage. There's an enforcement tab there where you can take a look.
Yeah, and if you don't want to read the whole thing, scrolling down to the one paragraph that describes what were the text related to municipal advisory activity is definitely highly recommended.
So yeah, I think as we've seen in the news, the SEC has been active in this area.
I just want to highlight two things that Rebecca said that I think were really important. Is one, in all these cases, this was activity over a long period of time, for example. So we're not talking one isolated text, and we're also talking about pervasive activity. And I think this also was really clear even in the very early broker-dealer cases, where the folks who are supposed to be enforcing the bookkeeping rules, chief compliance officer, CEOs, other people in supervisory capacities, knew that this was happening while also participating in the off-channel communications. So, I think one question that comes up a lot is, what is a reasonable supervisory process? And that is actually can be a tough question, and is self-certification enough or not enough? And I know FINRA has some actual good guidance about this as well. So those things I think are tougher But I think what really came through these enforcement cases is that this was extended periods of time, pervasive activity that people who were supposed to be enforcing the internal processes were not doing. And I think that's really important to underscore.
Another thing in the OIBs too is, in addition to the undertakings that the commission required firms enter into, firms had a paragraph where they described the remedial activities they themselves elected to undertake. So there's a lot of different things firms put in there.
So that covers, I think some of the SEC actions, and maybe I'll go to Bill next. Has FINRA been also sort of in this space? I know you talked a little bit earlier about some outreach and some guidance. How about some of the other program areas at FINRA?
Yeah, so FINRA has been in this space as well. For many years, FINRA's been reviewing for and identified in the field instances of reps or firms using personal emails, personal text messaging, or some type of social media app to sort of conduct business without the member firm's knowledge. As we said, it's a constantly evolving area. So off-channel communications is kind of a newer term that we're using, but it just really refers to communications sent or received through a medium that a firm has not authorized. And that's something that goes back years and years. The exam program recently conducted a sort of review of 70 firms' practices related to off-channel communications. Common findings there related to failure to maintain adequate supervisory systems and a failure to preserve and reasonably supervise off-channel communications. Additionally, FINRA enforcement has had AWCs on similar issues, not necessarily with BDMAs, but certainly with broker-dealers, where the fact pattern can apply to sort of any firm within the industry. Firms failing to capture and retain business-related text messages, apps or reps disciplined for using WhatsApp, reps using UK affiliate emails to sort of circumvent the firm's internal capturing system, and just more of using personal cell and text records. Further review can be found, or if you're curious about particular cases, FINRA Disciplinary Actions Online has a lot of information on this, and we'll have the specifics of individual cases as well.
Thanks. I think in this question, and maybe we'll start with Dave, and you touched on this a little bit earlier, but just sort of asking, I guess, generally about, what kind of feedback are you getting from the industry? And so, maybe starting with, for example, what kind of questions are folks coming to you with primarily?
Yeah, I mean, and so I think it is, very legitimate to say, right, this is a rapidly evolving area. I mean, I remember when we first got email at my law firm, right? And then this was 5 years into my practice. And so now you think about all the ways in which people can communicate. And so it does make complying with these rules more complicated. I mean, broker-dealer rules go back forever. MSRB rules do not, municipal advisor rules do not go back as far, but they're still kind of based on the same idea that, you would probably be communicating by U.S. mail, FedEx, email, and talking, and that's pretty much it. And that's not the reality we live in. So I think the real tricky question becomes, and talking about self-certification and how can we be sure of it, that to me becomes the real trick, right? Like, at what point do we have to start? Even though I may have a personal phone, I may have a phone that was sent to me by my company, I still might have another phone, who knows, you know what I mean? And there's many other ways I can communicate that go beyond just controlling my phone. And so I don't want to jump ahead of Bill, but FINRA in particular has a lot of good things that you could talk about, and like the question of when is self-certification enough? And I think what we saw from these enforcement actions was you might have a policy and procedure that talks about self-certification, and people are happily signing it every month or every 3 months or however often you ask them. But the folks knew that those self-certifications were not true. And that's a really easy case, right? So you're seeing people certify quarterly, you're like, wait, you just texted me, you know what I mean? Like, how can you be signing this if you just texted me? Like, they're not challenging internally facts that they know. And it kind of relates to what was talked about in the first session about if you see something, say something. But also, important in terms of a meaningful review is, Are you looking at a transcript file for a particular deal and there's no emails at all? You know what I mean? Okay, how are you guys talking? Like that's a red flag. So there's some very practical things that you can do to follow up on this. And I know, Bill, you might have one or two more in this area. I don't know if you want to mention them now about how to test the self-certification.
Yeah, I mean, it's always going to be a facts and circumstances consideration of each firm, right? But with respect to self-certification, you know, if a firm has processes and procedures in addition to the self-certification process, you know, that goes a long way towards making the system probably more adequate, more reasonable, given the scope and size of the firm's business.
Well, but just there, you know, I think the question, this is a tough question. I think it's something that's actually tough for people to deal with in practice, because in my mind, like a self-certification would be enough, right? At least as an initial step. Like I'm going to say I would think self-certification would make sense. But once you start to know that those self-certifications are false, then I think you get into the range where what Bill's talking about. Now you have to add additional steps.
I would agree with that, yeah.
I just jump in and point out that under our supervision rules, and that's on the dealer and MA side, that we've talked about the procedures being reasonably designed, looking at the firm size, type, and of course the type of customers. So I do think that while self-certifications may work in some instances, that if you're looking across, again, at your firm size and type, that may not always be just your magic ticket to say that basically now we've complied. So I would encourage firms to look holistically about what reasonable supervision and what a system looks like based on the encompassing of the work of their business.
And a fair point, because especially when I was in private practice, right? Some people had a situation where there was a principal on every deal. And so to me, that would make a self-certification make more sense, because you're going to have that oversight all the time on every single deal. It becomes less realistic that you're going to be able to follow a deal along if you don't have that. I think that's what you're getting at, right?
Mm-hmm. I'd say also, you know, given that this is an audience of municipal advisory firms, there's kind of two ways. The obligation is coming at you guys from sort of two directions. There's the sort of general, okay, are you maintaining the electronic communications properly under the relevant SCA Act and whatnot? And then also, you know, are you maintaining, do you have records of what advice you're giving to your customer or your municipal entity customers as required under the or the municipal advisor rules and like the fiduciary duty rules?
Yeah, and I definitely don't want folks to forget that it also applies to some internal communications, again, if they form the basis for your recommendation. Rebecca touched on something earlier, and it kind of always makes me laugh, because, you know, I can see the reaction from private practice, because I might have had this reaction when I was in private practice. But another helpful thing to think about when you're thinking about rules is like, the reason why we need books and records, right, is in order for a regulator to do their job. And so it's not that surprising that if somebody shows up and they say, hey, we want to see your records about this particular deal, which was, by the way, a bad deal, and you have nothing, then that immediately raises suspicion. And so part of the phrase that sometimes used is you kind of have to think, when you're thinking about what is a reasonable books and records compliance process, is like, what does a regulator need to see? And people are like, well, that you might as well ask me what a Martian, like get my head in the head of a Martian, because I have no idea what a regulator wants to see. But I don't think that's really true. Again, just put yourself in that perspective and say, for example, the famous, you know, what do you want? We're having a meeting. What do you want to order for lunch? Chicken or turkey? Okay, doesn't matter, right? But the question of who's showing up to a meeting definitely might matter. The question of when a meeting occurred might matter, right? Because did this meeting occur before or after a disclosure decision was made? So those are the kind of things that it's sometimes helpful to just put yourself in the perspective of, okay, if I was law enforcement, would this record be meaningful to me or not? And again, that's never going to be a perfect answer. You're not always going to be able to know yes or no, but I think you can get closer, and you can definitely get closer to what a reasonable perspective would be. I don't know if anyone disagrees with me on that. But.
No, I think that makes sense. I think I will also point out, I'm just looking at the dealer rules which are much more prescriptive on dealer supervision in G27, that we talk about being able to make and maintain and review those types of communications, right? But it talks about too communications with the public regarding the municipal securities activities. I would just would raise for the amazing rule in the room, although the rule related to G44 is a more principle-based rule. Rebecca kind of focused on all those things that was talking about the communications with the issuer client, There are communications that happen that is more than just with the issuer client, that is related to municipal advisory activities, especially when we're talking about on a specific deal. So think more broadly about just basically that two-way conversation with the issuer, but there could be other members of the deal team that those communications are going on with as well.
Yes, that's very important.
Yeah, and I think you're sort of touching on this idea of, that there's a reasonableness to the layer of supervision and to the system that's been implemented. But I think, we've also talked a little bit before the panel, we were talking about this relating to MA activity and relating to the business as such. And, can you talk a little bit about, so what is the scope of that relating to? How do we think about that? Is that a supervisory issue? I think you started talking a little bit about this, but.
I mean, I was going to say, I guess I would start with, I think firms very regularly capture written communications as well as emails. And so they've already kind of thought about this. I think what we're dealing with is a new form of communication that wasn't necessarily being captured by a firm's record-keeping system in the way those other communications were. So I guess I'm not so sure why this is so different than how we think about records in the context of other writings and emails and other ways municipal advisors, it has to be in writing, broker-dealers, it's all communication. So that gets a little bit trickier. But Dave, I think you're about to jump in.
Yeah, but so the words relating to might, there might be a little too much scrutiny on that. So one, I think part of the issue that has been discussed and makes it hard is the practicality, right? So I remember when COVID started, I was still in private practice, and all of a sudden you're having all these Zoom meetings, and it's like, hey, turn off the chat. Because if you're not able to capture the chat, you need to turn off the chat. And so you constantly start to have to think about what other ways are there for my people to communicate. So that's one aspect of it. But when you think about what relating to means, it's a fair question, and certainly some hypotheticals to answer one of Eric's earlier questions have been posed to us of like, wasn't everything relating to municipal advisory activity? Isn't the chicken sandwich question related to municipal advisory activity? Because that is a meeting about the deal, and so whether I have a chicken sandwich or a turkey sandwich relates to municipal advisory activity because it relates to the deal. And I would say, of course, no. I think when you're talking about it's the fact that the communication is about municipal advisory activity, and so maybe like a little bit of a subtle point, but the substance of the communication still has to be about municipal advisory activity. You're not taking it one step further to something else. And so to me, that's what the relating to means. It's the actual communication relates to municipal advisory activity, not that I can go one or two steps, extrapolate one or two steps from the communication to my job. I don't know if that is helpful.
Can you maybe talk a little bit about, I guess from the SEC's perspective, or from folks who are, making policy in this area, what kinds of concerns or sort of struggles have they sort of voiced about some of these rules, or some of, trying to apply the rules in this framework or this context?
So again, I think the struggles are, at what point is my supervisory process reasonable or not? How far do I need to dig? Do I need to take my employees' personal phones every week and scroll through their text messages? Like at what level is this okay? And, again, I really think that goes back to what problems are you seeing or not seeing? From my perspective, certainly early on in this regulatory scheme for municipal advisors, for example, a self-certification was eminently reasonable. But then once again, if you're seeing violations, if you know of violations, if you are yourself participating in violations, then that obviously becomes less reasonable and you have to build in other steps. I think people, it's always going to be a judgment call, but I think what we've seen from the enforcement cases is they're not really like, these were not tough cases. I mean, these were pretty obvious, consistent, continual violations. It wasn't, oh my God, one text went through and it shouldn't have. That was not the situation. So that should kind of get people a little more calm about the whole situation, because again, it is possible to design something that is reasonable. It is something that it's possible to design something that works in most cases. And then everybody may have a rogue employee. It's just very possible. You know what I mean? And so that doesn't necessarily mean you have to revamp your entire system. The solution to that might just be that employee gets fired, or there's some solution to that particular employee. So I think it's important to also be a little bit realistic. You've heard this word reasonable used many times. Reasonable doesn't mean perfect. And I think that's important to remember as you're going through this process. You can come to some reasonable answer. I don't know.
Just to add on to that, another kind of important detail that I mentioned earlier was that the supervisors responsible for implementing the WISPs and principles were doing it. So if you're in charge of implementing the rules and you're not following yourself, I mean, I think this really can create a culture of non-compliance in a farm. So that is, part of why it wasn't working. There was a policy and procedure there, but it wasn't being really enforced even by the people who were supposed to be enforcing it.
So Dave, you talked about self-certification as a reasonable first step. And Rebecca, you were talking about, firms already have, programs in place to review communications at some level. Maybe Bill, can I ask you to talk a little bit about has FINRA seen any effective practices? What will be a next step after that first step?
Sure, definitely. Effective practices that we've noticed out in the industry are, we've noticed the importance of training. So ensuring that reps are fully aware of the policies. It's one thing if you have great written supervisory procedures, but if they're just sitting in a book somewhere and no one reads them, then it doesn't really do much good. We found it can help to have a central definitions area so that kind of everyone knows where to go to kind of get any questions answered. Other effective practices would include, updating a lexicon for electronic communication reviews. Most firms already do some type of thing here, but to include the names of common platforms like see me on Facebook or text me offline or chat offline, to update a lexicon to kind of try and grab emails or other communications that are already on the firm's network that seem to be directing folks off of the firm's network is a good practice. I think Dave touched on this before as well, monitoring the volume of communications for low use. So if you have a registered rep who is doing a lot of business but is not using a lot of email, that could be a red flag that this individual is conducting communications somewhere other than the place where the firm is able to capture the communications. And then providing guidance to associated persons on how to respond if they receive a communication off channel. If they receive a text message from their client, how are they to respond? How are they going to try and get that communication back onto an approved medium in the event that that's appropriate or necessary?
And I know that one is very crucial and one that folks struggle with all the time, particularly in municipal bonds, where they don't want to tell the client, hey, we need to email about this. We can't talk about this on this platform, and they really struggle with the customer relations part of that. But I think having a process, having some tips for your team about how to deal with those kinds of requests that come in from other people is really important and can be really helpful. Because when I was in private practice, I saw several firms that were my clients very successfully navigate that with their clients, where they were able to consistently redirect their clients to on-channel communication. And it's, I'm not going to say it's always easy, but having tips and having training on how to do that, I think is extremely useful.
Yeah, I'll just jump in and say at least a couple of things that we've heard from MAs is that since there is a sensitivity to that relationship, maybe forwarding that type of off-channel communication to your email and responding to the client. So then it becomes part of course, the internal workings of the firm as a captured record. And then that is also a way to help the issuer client to become at least more aware of the steps in which basically you're wanting them to follow.
And I mean, I saw this, this happen in disclosure where, once you start doing this enough, and then I think the market kind of understands, just, telling your issuer client, hey, from a regulatory perspective, we have to have this discussion on email or whatever. And then it really does start to take over. I remember when due diligence calls on municipal deals first started happening and people would be really apologetic and, why do we have to do this? But then over the course of time, you saw those apologies disappear and people just became used to this as a matter of course. So I do think, if there's kind of consistent effort to redirect clients to on-channel, it just seems less weird and they're more willing to accept it and they start to understand it because it is an education process for them as well.
So we talked about, there's a single rule set and then there's, sort of a reasonableness kind of gloss in some situations. And then there's these sort of controls, technological steps that folks can take. But sort of trying to establish a baseline, how do you think about the difference between some smaller firms versus larger firms? That's an issue that I think comes up a lot in especially the muni space. Things like, someone only has a personal phone that they do all their business on versus someone has an IT department. How do we sort of factor that into the approach to compliance?
You go first.
Flip the coin.
Flip a coin.
I mean, it's not even sometimes so much like the small versus large, although obviously that makes a difference. But because sometimes it can depend on how teams are assembled. Some small firms, everybody works independently, so the compliance officer might not have an idea. Other small firms, it's totally a group effort on everything, so sometimes it's easier to keep track. But I guess really you have to think about it as from a designing a compliance perspective is how would I know if people are not following our process? How can I be sure? And so I've had conversations when I was a private practice with people say, I will know if people are texting. You know what I mean? It will come up because either the client will tell me or something, there'll be some flag, and then I can respond appropriately. So I think those kind of people, it was easier for them to deal with like a self-certification type setup. But you had other firms that were more dispersed, and you really had to start to implement these periodic checks of communication to look for keywords like, text or whatever, you know what I mean? That you would need that to be reasonable. So it is a combination of small and large, but really I think the central question is like, how would I know if someone's not following our process? And then what step can I put in to test that?
Yeah, I would agree with that. I think that that's why we talk about there's no one size fits all to this type of basically supervisory controls and procedures, but it does come down to what you think is going to be reasonable for your business. I kind of would say that if you're talking about a 2-person shop, some of this may be a little bit more easier to accomplish than some of the larger firms that are having to also review for correspondences under the rules. So I guess this is my thought.
I mean, to that point, right? Definitely work with smaller firms. They're like, well, some compliance person is telling us we have to do we have to run a check on 10% of all the emails. And I'm like, you're on all the emails anyway. You know what I mean? So like, you don't have to implement a separate check. And when you're thinking about what is reasonable, again, yes, it'd be wonderful if every situation could be addressed by guidance. That's never going to happen. But talking to other folks and seeing what they do really helps you to get to a point of reasonableness because everybody's struggling with the same issues. And so you can get good ideas from other people. And just the fact that you went through that process and saw what works in the industry, what doesn't, and modified it for your business is always helpful from a regulatory perspective of just being able to demonstrate that you thought about something and that in good faith you implemented something to try to respond to it. Yeah, Rebecca, I mean, is that fair to say like that?
Yeah, absolutely. And like I said, all these firms did make a change in addition to the undertakings that we asked of them. They also voluntarily thought hard and critically about their business and their folks and what they could do to make a change. And whether it was technology or more training or designating the person to kind of be at the top of this, like firms thought about it and we had, some very small firms and some very large firms. Of course, in the commission's broker-dealer actions, they were very large firms and they needed something a little bit different. But there's a lot of people have been thinking hard about this.
And I know Rebecca, you mentioned earlier sort of the distinction that all communications versus sort of the written communications, the distinction between, what's required for broker-dealers versus municipal advisors. Are you seeing, is it mostly the text, or are you also seeing voice and phone issues sort of in this space?
I mean, I myself only participated in the municipal advisor cases, and it was predominantly texts that were the problem.
But I mean, obviously an important distinction between what the rule requires. And so municipal advisors can be very thankful that their rule says all written communications versus all communications.
So we've got about 10 minutes left in the panel. I'm going to go to a few of the questions that have come in over Slido here. So how about this one? So under what authority does FINRA and or the SEC have to get access to an individual's personal device with respect to off-channel communications?
It's something we do very infrequently. I think it has to go through a number of approval processes. Our lawyers are involved with that sort of thing. Off the top of my head, I cannot think of a single instance where we've asked to review someone's personal device. In general, we kind of restrict ourselves to the firm devices of the firm laptop, that sort of thing. So I don't know that it's happened in the past. I think that we do have the opportunity under maybe 8210 or something like that to request those types of things if we feel like, or if we have some type of evidence that there is some type of work being done off of the firm's approved channels.
And I would add, when we open an investigation, our typical first move is to ask for documents, to request them. And I would know, the firms in our investigations all cooperated and produced information to us. And so I think that's where we always start. And then we kind of, from there, to the extent we need more information and folks aren't cooperating, I think we would have to, just keep stepping it up incrementally. But that's where we always start, is to ask.
So the first step is not to raid an office and take people's personal phones. Yeah. I think that's what we're getting at.
So I have a question here. Are we to record communications texted to us by clients that we didn't respond to? So are we trying to avoid text communication, but should that still be maintained?
So the rule requires that, essentially all communications related to municipal advisor activity be retained. So it is an interesting question. If your client sends you something substantive and then there's no other record of it, like you don't even respond, received or something like that. I think there could be some circumstances where that would be an item that would need to be maintained. It would just depend on what the substance of that incoming text is. But that is covered under the Exchange Act rule, and so also covered under MSRB rules and FINRA rules.
Yeah, the rule actually says outgoing, incoming and outgoing.
Right.
So here's a question. So what about phone calls that are not required to be recorded? And maybe that's, as part of books and records. For example, a call between trading desks. Are those required to be on some sort of company phone, or I guess should they otherwise be, maintained maybe for other purposes?
I mean, and for the most part, there are only specific circumstances, in my understanding, where the firm would have an obligation to make recordings of phone calls between the firm and its customer, or like anybody at the firm. And so, unless the firm was already subject to one of those, to that, I don't know that there's any circumstance when they would need to be recording all phone conversations. I don't think it's required by books and records rules, unless they're subject to the recording.
Yeah, I mean, I can't envision a situation where that would be, the requirement is the requirement. And so you're essentially saying, do I have to save things that are not required? Like, do I have to save recordings of phone calls that are not required to be saved? And so I think the answer is no. Could there be some theoretical possibility? Probably, but it wouldn't be something that I spend a lot of time worried about, because those things, that's actually generally a more clear example of when you need to save stuff and when you don't.
I'll say that, the contents of that type of phone call the firm may want to record them in some way, like if it's a call with a municipal entity customer and there's advice provided over that phone call, the firm may want to record that so that, it has a record of what it was actually doing during a particular time frame, so that when a regulator comes in and says, okay, you had an engagement with this entity, what did you do with them? They kind of have that to hand, but that's not exactly the same thing.
Yeah, because it's more like doing a memo to file, or
Right.
some sort of self-preservation that you're doing to help yourself versus a regulatory requirement.
So I think, unless there's some new questions coming in, maybe we'll try this one last one. Shouldn't supervision begin with the distribution list for a transaction and the contact info provided thereon?
I mean, that's a good example. Is you're trying to think about, what kind of who would folks on the deal be communicating with, and so so a good way to test it, right? If you had some sort of test, is to look for exchanges with certain numbers, and those would only be the numbers on the distribution list. I mean, that does make sense, certainly, versus doing a full scale investigation. And I would imagine, as some investigation proceeds, like it's going to proceed in that more logical way. If you have that kind of information, like this is who was on the deal, so we're looking for, communications back and forth with these phone numbers, that would make sense.
All right, well, I think we're a couple minutes early, but I hope folks don't mind having a couple more minutes to try to get some lunch. Thank you very much to the panelists. Really appreciate it. And we'll see you all back after.